Okay, this is People of the State of Michigan versus Jose Archer, docket number 20-50FH. And Mr. Archer, this is the time set for a plea. And if that's how you intend to proceed, would you raise your right hand, please?
We go back into that shower.
Do you solemnly swear or affirm?
Sorry, Judge, I'm getting a lot of.
I know it is the jail. Hang on. Tell them I cannot conduct proceedings with all this noise in the background. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Mr. Archer, you can put your hand down.
Stabby, I'm going home. I'm getting fucking paid. I don't get paid.
Hold on, we're calling the jail to get the noise dealt with. Because right now, my court recorder says she can't even take a record. Okay, it sounds like maybe they shut a door. Mr. Archer, you have the right to be represented by an attorney. You are represented by Mr. Cornish, who is present. And this is a plea, I believe, from what I was previously told, it counts 2 and 7. Is that correct, either Ms. Polda or Mr. Cornish?
That's correct, Your Honor.
Yes, sir.
Okay. And then, Mr. Cornish, will you waive reading of the balance of the information?
Yes, Your Honor.
Okay, Ms. Polda, would you read counts 2 and 7 then?
Yes. State of Michigan, County of Ingham, in the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on or about July 1st, 2017, at 1912 South Rundle, City of Lansing, Ingham County, the defendant did in count 2 make an assault or an assault and battery upon Dora Archer, an individual with whom he had a child in common, or an individual with whom he had a dating relationship contrary to the law. Take notice that the defendant was previously convicted of assaulting or assaulting and battering his spouse, former spouse, an individual with whom he had a dating relationship, an individual with whom he had a child in common, or a resident or former resident of his household, or of knowingly assaulting a pregnant individual by violating the law on or about February 3rd, 2009, and violating the statute as well on or about August 25th, 2001, and therefore upon conviction will be subjected to an enhanced sentence under the law. This is a felony punishable by up to 5 years and or $5,000. This is also known as domestic violence third offense. And did in count 7 attempt to commit the following listed offense, and in that attempt did act toward the commission of that offense, but failed in the perpetration or was prevented in the execution thereof contrary to the law, and that he did by threat or intimidation discourage or attempt to discourage an individual from attending as a witness, testifying, or giving information at and or encourage or attempt to encourage an individual to avoid legal process, to withhold testimony, or to testify falsely in a criminal case where the crime was punishable by a maximum term of imprisonment of more than 10 years, or imprisonment for life or any term of years contrary to the law. This is a felony punishable by up to 5 years and is also known as attempted witness bribing, intimidating, interfering criminal case punishable by more than 10 years. Take notice that the defendant was previously convicted of a felony or an attempt to commit a felony, and that on or about July 7th, 2004, he was convicted of the offense of assault with intent to rob while armed in violation of the law in the 30th Circuit Court for Ingham County, State of Michigan. Therefore, the defendant is subjected to the penalties provided in the law, which is 1.5 times the maximum sentence on the primary offense or a lesser term. That makes count 2 punishable by 7.5 years, and it makes the count 7 punishable by 7.5 years maximum. This was done against the peace and dignity of the state of Michigan.
Mr. Archer, you're being charged here with domestic assault and battery, third offense, and attempted witness intimidation and a felony punishable by more than 10 years. These are each felonies, and because the prosecutor is proceeding against you as a habitual second offender, it makes each one punishable by up to 7.5 years in prison. Also, if you were on parole at the time of either of these offenses, it would be a mandatory consecutive sentence. Have you had enough time to talk about these charges with your attorney?
Yes, ma'am.
Do you understand the charges against you?
Yes, ma'am.
Do you have any questions about what we're doing?
No, Your Honor.
And how do you want to plead?
Guilty.
If your plea of guilty is accepted by this court, it means you won't have a trial of any kind, and you'll be giving up the rights that go along with a trial. That means you'll be giving up the right to a trial by jury, or if you didn't want trial by jury, trial by judge. You'll be giving up the right to be presumed innocent until proven guilty, and to require the prosecutor to prove your guilt beyond a reasonable doubt. You'll give up your right to have the witnesses against you appear at the trial and to be able to cross-examine them, as well as your right to have this court order any witnesses that you might have to appear at the trial. You'll give up your right to remain silent and not to have your silence used against you, or in the alternative, your right to testify if you wanted to testify. Also, when you plead guilty, it did for a minute, and now it's just as bad as ever. Okay, thank you. All right, thank you. Also, when you plead guilty, Mr. Archer, you need to know that it changes some things on appeal. The first is that you don't get an automatic right to appeal. Instead, you have to ask the higher court to hear your case, and they have to agree to hear it. And then the other thing is when you plead guilty, there are a lot of issues that you cannot even appeal like you could if you went to trial, got convicted. Do you understand those rights?
Yes, ma'am.
Also, if I accept your plea, it means you cannot come back later on and try to say that the plea was the result of some promise or threat that no one told me about today. Do you understand that?
Yes, ma'am.
It also means you cannot come back later on and try to say that it really wasn't your own choice to plead guilty today. Do you understand that?
Yes, ma'am.
And then I did make a Cobb's agreement on this case that I'll get to in one moment, but first, Ms. Polda, is there a plea agreement?
Yes, Your Honor. In exchange for the defendant's successful plea and sentence to counts 2 and 7, the people will move to dismiss the remaining counts. He would plead to those 2 counts as a habitual second offender. There was also an agreement under People v. Killebrew that the defendant be sentenced in the D2 cell on the E grid, which is 7 months to 28 months.
Okay, and then I agreed to a Cobb's agreement of sentencing the defendant to time served as of the day of sentencing. And I did that based on the following representations and the situation as it stands right now. One is that I indicated there would be a probationary term for the protection of Ms. Archer. And 2, as has been stated by the prosecutor, I was told that the guideline range was 7 to 28 months. And I am of the belief that by the time of sentencing, Mr. Archer will have approximately, maybe give or take a week, I'm not sure, about 456 days credit in already. So that left me with only, if I gave him the minimum sentence under the guidelines of only 13 months in the Michigan Department of Corrections. And I felt that the oversight and supervision of probation was a better way to protect Ms. Archer than a very short Department of Corrections sentence that would be questionable with respect to programming, et cetera, if there were only 13 months left in it. Now, all of that, the plea agreement, the prosecutor said, and my Cobb's agreement, is all of that a complete statement, Mr. Cornish?
It is, Your Honor. Thank you.
And Mr. Archer, if you heard all that, is all of that your understanding of this as well?
Yes, ma'am.
And do you agree with it?
Yes, ma'am.
Now, I've outlined the things that I relied on to make this Cobb's agreement. And I really doubt this would happen, but if something were to change, something I didn't know about, that I've relied on in order to say that I would give you the time served, if something came out by the time of sentencing, then I would tell you if it changed my mind, and I'd give you a chance to take back your plea and start over. You got all of that?
Yes, ma'am.
Has anyone promised you anything else that has not been said here right now in order to get you to plead guilty?
No, Your Honor.
Has anyone used any threats?
No.
Is this your own choice?
Yes, ma'am.
And are you pleading guilty because you believe you are in fact guilty of these offenses?
Yes, ma'am.
Okay, so we're talking first about the domestic assault and battery third offense. And tell me what you did on or about July 1 of 2017 regarding Dora Archer.
I went over to our residence at 1912 South Rundle. We had got into a verbal altercation at that point, and which led to a physical where I hit Dora numerous occasions, and one of them blackened Dora's eye.
Okay, and you hit her on purpose. In other words, it was not accidental, correct?
Yes, ma'am.
Okay, and you and Dora have a child in common, correct?
Yes, ma'am.
All right, and so charges were issued. I understand there's a little bit of a longer history here, but at some point after charges were issued, you had contact with Dora, is that right?
Yes, ma'am.
Tell me about that.
After the first arrest, or when I was in the city jail, I had called Dora on numerous occasions and talked to her on the phone and asked her, would she not show up to court?
Okay, and you did that obviously for the purpose of persuading her not to show up in court, correct?
Yes, ma'am.
And that was when you were facing all of these felonies that are on the information, including the 20-year first-degree home invasion, is that correct?
Yes, ma'am.
All right. And all of this happened in, well, the assault at 1912 South Rundle in Lansing, Ingham County, the witness intimidation attempt also in Ingham County, is that correct?
Yes, ma'am.
Has the court complied with MCR 6.302, Ms. Polda?
Yes, Your Honor.
Mr. Cornish?
Yes, it has, Your Honor.
Are you aware of any promises, threats, or inducements other than those already placed on the record, Ms. Polda?
No, Your Honor.
Mr. Cornish?
No, Your Honor.
The court finds the plea is understandingly and voluntarily made without undue influence, threats, or promises of leniency. It is an accurate plea. It's supported by the testimony. The plea is accepted. I'm aiming for 5 weeks on the sentencing, which is the minimum that I can do for the probation department to prepare a report. So that would take us, Mr. Cornish, to Monday, March 8th at 2:15, if that works for you.
That works great, Your Honor.
Okay, so Monday, March 8th at 2:15. And Mr. Archer, are you gonna be okay with doing the sentencing remotely from the jail like we did the plea?
Yes, ma'am.
Okay, thank you. That simplifies things. Then we will see you back on Monday, March 8th. And you should just know, Mr. Archer, that someone from the probation department will be setting up an interview with you. It's really important because it's for the report that I'll use for sentencing. So unless you have
Okay.
any questions, we are all set, and you can tell them at the jail that you're all done.
Okay, thank
Your
you.
Honor. I'll talk to you guys later this afternoon.